My Lords, good afternoon. The restitution. As far as private international law is concerned, we have reached the happy position where all parties agree that English law applies to this claim. That's recorded in the Statement of Facts and Issues at footnote 5, page 23. That obviously may be disappointing in terms of the development of the jurisprudence of Guernsey, but it does at least mean that we don't need to spend time debating which law applies or whether Guernsey law recognises a claim in unjust enrichment, and if so, its scope.
There was some pragmatic basis for saying English law applies, as well as a legal basis.
Oh, I should say we had set out several pages in our submissions saying why we thought English law applied, so it
Yes,
did.
right.
It wasn't just a convenient concession.
No, all right. Well, it of course relieves us of
it does shorten matters somewhat.
very interesting exercise on which judicial assistants have been breaking their heads.
Well, it does. One of the consequences is we don't have to go into some passages of Norman French cited by Lord de Goldsmith without translations attached.
That's in the best traditions of the Privy Council. we aren't sitting here as a United Kingdom court.
Well, indeed. Yes. So the restitution. This is a claim on which the trier of fact, the Lieutenant Bailiff, found in our favour, found that the former trustees were liable to Oscatello in restitution at paragraph 130 of the Lieutenant Bailiff's judgment.
Who lost out in the Court of Appeal.
Yes, the Court of Appeal overturned that on grounds that I'm afraid are flawed, both in respect of what they did to the Lieutenant Bailiff's findings of fact and how they applied the law to the facts. Now, the Lieutenant Bailiff, if I could invite you there, it's in Core 1, the number is page 187. It's 187 in the electronic as well. And you will see there at paragraph 128 of the Lieutenant Bailiff's judgment, he made, in this paragraph and over the page 188 particularly, he made a number of factual findings which the Court of Appeal expressly or impliedly reversed or overturned. First of all, and I refer myself particularly to the last 8 lines in paragraph 128, where the Lieutenant Bailiff says this: in my view, it's clear in the materials before the court that the debt on loan account 5962 was discharged by Oscatello at the request, or at least with the knowledge and consent of the former trustees. And that was not done in consideration of the transfer of assets to Oscatello under the framework agreement. I reject also the submission that the discharge of the former trustees' debt on loan account 5692 was intended by Oscatello or seen by the former trustees as a gratuitous benefit to be conferred on the former trustees by Oscatello. That, as it seems to me, would be wholly inconsistent with the evidence of Mrs. Bleasdale. Now, so you have no less than 4 findings effectively being reached by the Lieutenant Bailiff. First, the debt, the former trustees' debt account thing was discharged by Oscatello at the request, or at least with the knowledge and consent of the former trustees. Secondly, that was not done in consideration of the transfer of assets to Oscatello under the framework agreement. Thirdly, that in making that payment, Oscatello did not intend to confer a gratuitous benefit to on the former trustees. And fourth, that the former trustees did not see the payment as a gratuitous benefit, because that, and he found himself, amongst other things, on the evidence of Mrs. Bleasdale. Now, the Court of Appeal at page 78 of the same bundle, electronic page 78, addressed this matter from paragraph 174 as the relevant passage, where at 174 they confirm that they do see it as a matter, as an evidential issue.
Sorry, what's the electronic page?
78, my lord.
78?
78, same number.
Thank you.
78. They confirm at paragraph 174 that this is an evidential issue. And then at 175, they say this: there's no evidence of a request by the former trustees that Oscatello discharge the debt owed by the TDT to Couchthink, nor in our view are the circumstances such as might suggest that the participation of the former trustee in the events of December 07 should lead either to such an inference or to the inference that they consented to Oscatello discharging the loan. So they expressly overturn Lieutenant Bailiff's finding that there was a request from the former trustees, either express or implied, to discharge the debt. Then at 176, I need to read just a passage from the end of 176, the last few lines, and then into 177. Picking it up 6 lines into 176, they say this: it would make no sense that immediately after the arrangements of December 07, the assets of the TDT through the ultimate shareholding in Oscatello would embrace the liability of Couchthink, while at the same time the TDT would be immediately liable to Oscatello in restitution for the cost of the discharge. The complexities of this aspect of the present case mean that it does not sit easily within the type of case most readily envisaged under the principle enunciated in Falk. Adopting the approach set out in Falk, however, we do not discern in the present circumstances anything to infer that Oscatello could properly have been acting in the reasonable expectation that it would be entitled to an immediate recoupment from the former trustee.
So what is the sense of that second or third or the fourth sentence in 176? They're saying that they're postulating that on an opposite hypothesis, immediately after the framework arrangements, the assets of TDT through the shareholding in Oscatello would embrace the liability to Couchthink. Why would that make, which then would be dischargeable by Oscatello?
I think what they're saying is that
the intention must have been a wipeout.
it didn't make... I beg your pardon, Mark.
Yeah, so go on, please.
No, I think they're saying it didn't make sense for there still to be a liability which the former trustees would owe to Oscatello once this transaction had happened. And I think the embracing language is because the former trustees remained effectively the holding entity of the group. So it was then the former trustees through Eliza and Oscatello holding the companies, I think. And what this...
But, I mean, if Oscatello was liable after the framework agreement...
Or the former trustees.
Well, I was going to say, if Oscatello... Because Oscatello was intended to pay off this, wasn't it? I mean,
it was foreseen. It was
received the monies with a view to paying them off. Okay, right.
But what I do submit about the passage I just looked at, my lord, is that the Court of Appeal has either overturned or has imposed a very heavy qualification on the Lieutenant Bailiff's finding that Oscatello did not intend a gratuitous benefit. And instead, what they seem to be saying in this passage that I've just read is that neither the Oscatello nor the former trustees expected Oscatello to be entitled to recoup the monies from the former trustees, or if the Oscatello did so expect, that was unreasonable, which seems to us to be what is being said here. And the gist of the reasoning in the first part of 176, which I haven't read, but your lordship see it there, 176, the gist of that reasoning seems to treat the Oscatello payment to Couchthink discharging the former trustees' debts as almost as part of the consideration to be paid by Oscatello for the assets it receives under the framework agreement. So effectively, they are either expressly or impliedly disagreeing with Lieutenant Bailiff's finding on that it wasn't, the discharge of this debt was not part of the consideration moving to Oscatello for the shares it was receiving.
Is that just a finding of fact?
Beg your pardon, Madam?
Is that just a finding of fact? Doesn't that depend on the construction of the framework?
Yes, I mean, it'd be a question. There's a written contract. It'd be reading what the contract says.
No, I accept, yeah, and I rely on the contract, my lord.
Yes.
I do.
Can we just look at the relevant terms of the contract?
My lord, we can. I'm going to come to it. If your lordship wants to look at them now, I can, but I was going to just make a few other basic remarks on the way we put our appeal, my lord. I'm going to get there very quickly, my lord. If your lordship wants to be looking at it, the facility agreements at Core 2, 543, sorry, facility agreement, framework agreement, I beg your pardon, Core 2 at 543, and we'll come to that very soon.
What's the electronic for that?
The same number,
Same,
core
okay.
bundles are the same number, my lord.
Yeah.
At 543, and I think there's only one place I need to go on the facts beyond the core bundles. Your lordships, I can take this very briefly indeed, your lordships are well aware of the restrictions on appellate courts when it comes to overturning findings of facts, and although on the consideration point there is a document in point, as Lord Hodge rightly points out, on the other points about expectations and intentions, and whether it was expected to be a gratuitous benefit and so forth, the Lieutenant Bailiff also founded himself on Mrs. Bleasdale's evidence, as your lordship saw in the passage we looked at. Now, we've cited in our written submissions the Chubani case just because it helpfully summarises a lot of the House of Lords and Supreme Court authority. Appellate courts should not interfere with findings of fact unless compelled to do so. And that extends not only to primary facts, but also evaluations and inferences to be drawn from the facts. And there are very, very many good reasons, as your lordships know, for that practice. Now, we say that the Court of Appeal was wrong to overturn the Lieutenant Bailiff's findings and his evaluations and inferences, which were, in our submission, manifestly open to him on the evidence. Now, when I go to the facts, I would, to put the matter as neutrally as I can as a matter of what the law of restitution is, the facts I suggest that one needs to keep an eye on as being most likely to be relevant for the purposes of a restitutionary claim. There are fourfold, really. The first is whether there was an express or implied request by the former trustees to Oscatello to pay the debt, or whether they knew about it and consented to it. The second was the discharge of the debt part of the consideration to Oscatello under the framework agreement for the shares it received. The third was Oscatello expecting to be reimbursed in respect of its payment.
Sorry, what was the second again?
The second, my lord, was the discharge of the debt part of the consideration, which I may have said to Oscatello, the part of the consideration being paid to Oscatello under the facility, the framework agreement. Sorry, paid by, I beg your pardon, I did misspeak, paid by Oscatello under the framework agreement, beg your pardon, my lord. So was it doing this in return for the shares it received under the framework agreement? The third was Oscatello expecting to be reimbursed in respect of its payment? And the fourth, if so, did the former trustees know, or should they have known, that Oscatello had that expectation? Now, just on the facts, and I'm going to arrive at the framework agreement very shortly, but I ought to just set the background from the statement of agreed facts and issues, which your lordships, I think, have as a separate document.
Yes. Which paragraph?
I was going to start at 17, page 8, my lord. And just, I'm not going to recite these, but I'm just going to, your lordships will see from this document that these are agreed facts. And I was just going to recap the position coming into December 2007. And from paragraphs 17 and 18 of the Statement of Agreed Fact, you see that on the 20th of August 2007, the TFT entered into a loan with Coutthink of 100 million, guaranteed by the personal guarantee of Robert Chengi, which was subsequently increased to 122.5 million. You'll see from paragraph 22 over the page, foot of the page, that is where there was a deed of novation, foot of page 8 over to page 9. In 24th of August, there was a deed of novation where the loan was novated and the TDT became Couththink's debtor.
Yeah.
Then in December, we get the so-called Oscatello restructuring.
Right.
And you see from paragraph 25, foot of page 9, the framework agreement is entered into, and there's a description in the following passages in 26 and 27. And just to give your lordships the broad picture, I'm sure your lordships may have picked this up already, but the shares in a list of companies were transferred into the ownership of Oscatello, which was to be owned by Eliza, and in turn ultimately by the former trustees, and a share charge was given over those to support the Coutthink lending. There was also at that time, on the 19th of December, you see this in paragraph 27, the overdraft loan agreement was entered into. That's a loan of up to 371 million made by Coutthink to Oscatello for the purposes of refinancing listed debts in a schedule. And the list included the sum of 39 million odd due from the former trustees to Coutthink.
Can you just give us the page reference for that schedule?
The schedule, I'm actually going to come to it.
Oh, right, fine, yes.
I will come to it.
Yep.
So the 39 million odd included in the list of amounts to be paid, and that was due under the earlier August loan agreement and was recorded on account 5962. Then paragraph 27, you also see that there were two profit participation loans at the time in the sum of 150 million from two investors, one ISIS, which was connected with Coutthink, and the other New Ortland, which was two Icelandic investors behind that. And then at paragraphs 30 to 31 over the page, of page 11, one sees that Oscatello uses the money from Eliza and other monies to make the payments of 239 million, including paying off the debt on account 5962. Now, I've noticed that the agreed statement of fact says apparently in repayment in the penultimate line, but that's what the other parties were prepared to agree. The Lieutenant Bailiff found that it did repay that, and nobody's ever challenged that factual finding. The repayment of the Coutthink debt meant that, of course, that Mr. Chengi was no longer personally liable for that sum under his personal guarantee because it had been repaid. And I make that just to deal with one point made by the Court of Appeal. Because in paragraph 178 of their judgment, they drew an analogy with the TFT novating its Coutthink debt to the TDT.
Which is the page?
It's page 78, my lord, we're there a moment ago.
No, sorry.
Page 78.
Oh, I see, 78, yes, I'm with you. Yep.
Paragraph 178, page 78, with the Court of Appeal at the foot of the page, as I recall. In paragraph 178, they drew an analogy, or sought to draw an analogy, saying, with the Coutthink novating its own debt to the new trust. I'll start that sentence again. With the TFT novating its debt to the new trust, the TDT, in August 2007, is saying effectively that after the novation, the trustees of the TFT didn't owe any further monies to the TDT to reimburse them, and effectively saying, well, why should the former trustees be liable to Oscatello after this other transaction? And they were seeking to draw a parallel with that. And my lords, in my submission, there simply is not a parallel to be drawn there with that, the other deed of novation transaction, because as the Court of Appeal say in this paragraph, they say in the last three lines, they say, well, the arrangement could have been carried out in a similar way to that novation in the last three lines. But they then, of course, accept in the very next line that was not done, and of course it was not done. Now, what is objectionable about this reasoning, my lord, is that the Court of Appeal in that passage is treating the parties as if they had carried out this transaction by a novation when they plainly didn't. they carried it out in a different, under a different arrangement, and the fact that you might have conducted a transaction in a different way doesn't mean that you should treat the parties as if they had in fact conducted it in that different way. What actually happened here is there was no novation. Oscatello paid the debt, and that had real commercial implications because it meant that Mr. Chengi wasn't liable under his personal guarantee, which wouldn't have happened had there been a novation, because he would still have been liable under his guarantee for the debt. So it's not a legitimate analogy for the Court of Appeal to base themselves on. That brings me to the framework agreement, which your Lordships will have in Co-Bundle 2 at 543. Now, when we look at the framework agreement, we of course accept that the discharge of this debt by Oscatello was contemplated and foreseen in this documentation. What I would ask you Lordships to keep their eye on is three things. That we say the discharge of that debt by Oscatello was not part of the consideration payable. For the shares. Secondly, that Oscatello owed no obligation to the former trustees to discharge that debt. The debt owed to Cap thing. They owed no obligation to the former trustees. And thirdly, that there was no contractual agreement between the former trustees and Oscatello regulating the legal consequences of that discharge. Now, with that in mind, you will see the parties on page 543. To go as efficiently, I hope, as I can to the relevant terms, my lords, at 553, clause 2, funding, one sees the funding that's coming into ELISA, the Oscatello parent, at 2.1, and that is the contribution of the shares and the PPL, the profit participation loans, which are coming in. And then at 3.1a, what deals with the transfers of the shares, and says, 3.1 says this: on and subject to the terms of this agreement, and subject to clause 4.1, Silverville, just pausing there, that's another trust company, Silverville shall and TDD shall procure that Silverville shall, and then in A, immediately following the release of the existing share chart, transfer the respective holdings of shares with full title guarantee to Oscatello, on and with effect from completion, in each case free from all encumbrances whatsoever, and together with all rights attaching to them in respect of the periods after the completion date. So you have the TDT as the trust, transferring the shares to Oscatello. In D, I won't read it out. There's also, they have to procure Oscatello to give a share charge to Think. And then over the page at 3.2, page 554, at 3.2, and this is the consideration clause, one sees the consideration payable by Oscatello. The considerations payable by each of Oscatello and ELISA for the shares and the Oscatello shares respectively is as follows. And then by Oscatello to TDT, it's the issue of a number of shares in the capital of Oscatello, and to Silverville, the issue of a number of shares in the capital of Oscatello. So the consideration payable by Oscatello and ELISA for the shares is expressly set out. It's the issuing of shares in Oscatello itself to the former trustees and to Silverville, and that is the only consideration payable by Oscatello in return for the shares. Now, Then at 5.1 at the foot of the page, one gets governance and undertakings, and it says this, each of TDT, in respect of itself and Eliza and Oscatello undertakes to the Silverville and the investors, A, to apply or procure the application of the proceeds of the PPL loans and the proceeds of the TDT equity amount in the furtherance of the business. So the trustees for themselves and for Oscatello undertake to apply or procure the application of the profit participation loans they're receiving and the share contributions in the furtherance of the business. And the business means back on page 546, I hope it's legible in your Lordship's copies, because obviously the version that's been copied obviously had some highlighting, but business is defined in the middle of the page on 546. I won't read it all out, but for present purposes, what's important is the last few lines where it says, and the advancing and operation of the intragroup loans, the Iceland loan, and the company loans with a view to obtaining a profit. The reason that that's the relevant part for present purposes of what the business is because the Iceland loan is the overdraft which Oscatello is taking from Coutthink. And you see that from page 549 in the middle of the page. What the Iceland loan means an overdraft loan agreement between Coutthink as lender and Oscatello, dated on or about the date of this agreement. Now, and the framework agreement itself, you'll see at 581, is signed by Mrs. Bleasdale and others. 581, one gets her signature and also the signature of Mr. Clifford on behalf of the both sides of the transaction. Now, sorry, several parties to the transaction. I think Coutthink was also a party. Yeah. Now, there was also, as I mentioned on that date, the overdraft agreement was entered into with Coutthink, the Oscatello's overdraft with Coutthink, and that is at page 605. One sees that that is an agreement only between Coutthink and Oscatello, page 605, and it's important because of what appears at 606, which is that at clause 2.2, you see the following: the purpose of the loan is to refinance current debt as listed in Schedule 1 to meet potential margin calls of borrowers, subsidiaries, trading accounts, and the payment of interest in accordance with Article 3.
Sorry, where was that reading from?
2.2 on page 606.
Right, yeah.
That's the purpose of the lending to Oscatello. And the schedule you will find on page 615, Schedule 1. And one finds there the schedule of debts that will be refinanced. And the third entry, there's a pretty illegible totals column, but the third entry is the 39 million loan on account 5962.
Yeah.
And the share charge for information is on 617. That's entered into by Coutthink and Oscatello. Now, I have to inform your Lordships of a few more facts before we move on. Your Lordship saw that the Lieutenant Bailiff based himself also on the evidence of Mrs. Lydia Bleasdale, who was at the time of the events Lydia Peck, and I've cited to your Lordship that he actually cites quite a substantial passage from her evidence that's relevant to this, and he does so in the core bundle at 184 of the Lieutenant Bailiff. At paragraph 123 of his judgment, he cites quite a lengthy passage from Mrs. Bleasdale's witness statement. And of course, one remembers that his conclusions at the end of paragraph 128 are based themselves also on Mrs. Bleasdale's evidence expressly. He cites a lengthy passage from her witness statement, and also, one has to remember, she gave oral evidence at the trial before him. Now, as to who Mrs. Bleasdale was, Mr. Taub gave a little information on that this morning, but just to show your lordship the detail of that, in this same bundle at 170, which we're still in the Lieutenant Bailiff's judgment, at the foot of page 170, paragraph 87, sub 3, he describes Mrs. Bleasdale's position, and he says by the second half of 2007, following the transfer of assets from the TFT to the TDT, Chengi team had grown to about 20. Tracy Walker was away on maternity leave. So also from about mid-November 2007 until May 2008 was Chara Guernsey. The effect was that Mrs. Bleasdale effectively became acting manager on the TDT side during the second half of 2007. And of course, that's the time period we're dealing with on the framework agreement. And then at 4, Mrs. Bleasdale described her key responsibilities from 2006-2008 as liaising with clients and day-to-day administration for the Chengi companies administered by ITGL. In the process, she said she progressively acquired primary responsibility for the day-to-day dealings with R20. Responsibilities include liaising with clients and day-to-day administration for the Chengi companies, acquiring primary responsibility for the day-to-day dealing with R20. She was also, we see from Core Bundle 1 at 293, her own witness statement. We see that she was a B signatory for ITGL. That's her witness statement at 293, which is at paragraph 57. One gets that from 57, just over halfway down the page. She says, document signing procedures within ITGL involve what are called A and B signatures. Until June 2008, I was a B signatory and Tracy Walker was an A signatory, being a manager, and then she becomes an A signatory and a director of the corporate directors in July of 2008, which is after, that second part of the paragraph is after the events we're dealing with. Now, the passage that the Lieutenant Bailiff cited from Mrs. Bleasdale's evidence, which is back, that passage was cited by the Lieutenant Bailiff on page 184 of the Core Bundle 1. That passage makes a number of points. The evidence that he's cited, he cites from paragraph 131 onwards of Mrs. Bleasdale's statement, and those indicate that she was asked to sign and procure signatures on a funds flow document for Oscatello and Eliza, with R20 indicating they were happy for her to do that. They're the investment advisors to the former trustees, confirming that they're happy for her to sign that document. And we also see at the citation of her paragraph 132, just a few lines in, she refers to the payment of that 39 million, the loan being repaid, and she says no money's flowed through any of the companies, but payment was made from one bank account to another. This was accounted for as a loan from Oscatello to the former trustees and became the Oscatello arrangement. And then she says in 133, she's dealing with the period early in 2008, so that's just after they have signed the framework agreement and entered into the overdraft. And then he cites Mrs. Bleasdale from her passage 134, top of the page 185 of the record, 3 lines in. I also instructed that various payments by Oscatello be booked, including an interest-free loan to the TDT in the sum of 39 million odd, being the full amount of the Oscatello arrangement. This seemed the way to account for the money moving up to the former trustees in order to discharge the pre-existing borrowing to Coutthink. The lending which enabled the repayment of this borrowing was to Oscatello, and so the payment by it to the former trustees had to be accounted for in an appropriate way. And just to conclude on the facts, and I will get onto the law very shortly, and how we say the law applies, but just...
It should say, I mean, what happened, in fact, was so the payment by it to Coutthink had to be accounted for in an appropriate way, and she accounted for it by treating it as a payment to the former trustees who paid off Counting.
Yes.
Yeah.
Well, she treated it, she booked it as a loan,
Yes.
a loan from the former
That's right,
trustees.
a loan payment to them for them to pay off their indebtedness.
Well, that that the Oscatella had paid the debt, and that was to be treated as an advance to, or a loan to the former trustee.
That would be consistent with the general practice described elsewhere, of treating all intercompany payments as if they were loans,
There is, it's, yes.
rather than something special to this transaction.
There was a practice of treating movements of funds within the structure as loans
Yes.
between the companies. There was a
That
practice.
sounds as if she might just be saying, well, that's how we did it when we had an intercompany payment going on.
Well, I think our point is that she obviously thought that an obligation arose out of this. If I'm going to start trespassing on my substantive submissions. Would your Lordship permit me just to
Yes.
finish the facts, and then and then we can debate what their significance is. But my lords, Mrs. Bleasdale in these passages refers to some emails, and I should just briefly show you those. They're in Core Bundle 2, and they start at 648, which is also the electronic numbering. Where
648.
I'm going to start at 648, which is the end of an email chain that goes into the previous page, 647. And at 648, you have it starts with an email on the 20th of December from Coutthink to Lydia Peck, Bleasdale, Mrs. Bleasdale, which is where they are asking Mrs. Bleasdale to sign the attached document. And for Eliza, and you'll see at the bottom of the previous page, they then correct themselves to say also on behalf of Oscatello, please. But the document they want her to sign is the document at 649, which is a document headed Project Repayments Flow on Closing. And it says at the top, on behalf of New Ortland, ISIS, Eliza and Oscatello, the undersigned directors, attorneys of the companies hereby instruct Coutthink to effect the following payments on behalf of the companies. Consequently, Coutthink shall hereby be regarded as having been given irrevocable instructions in that regard. And item number 7 is the payment that we are concerned with. Now, just to pick up the email chain at 647, by the foot of 647, Mr. Aaron Brown of R20 is being copied. And at the top of page 647, we have Coutthink to R20 saying, "Dear Aaron, please find a more detailed analysis of funds flow in the attachment. Please be aware of changes of collateral, etc." So there's the more detailed analysis. We don't need to go there. It's at 650. But then, just to pick the story up, if I may, at 652. There's the end of an email chain that ends on the previous page again, but we have 21st of December. This is Coutthink writing to Aaron Brown of R20, copied to Miss Peck. Can we have the payments flow page signed by Eliza and Oscatello so that we can complete the funds flow today? Sooner rather than later, we have to send cash via SWIFT. And then over the page at 651, the foot of the page, Mr. Brown of R20 says, "Lydia, I'm happy with that." And then moving up the page in the middle of 651, chasing Mrs. Bleasdale, if you could do this quickly, it would be highly appreciated. We're trying to complete the funds movement today. And at the top of the page, Ms. Lydia says, "I will look at this now."
Do we gain much from these, in fact?
It's a question of evidence of the request, my lord, and it also goes to whose intention should be attributed to the parties concerned for that purpose. But I'm almost at the end of this. At 653, one sees that pursuant to that email chain, Lydia then sends the attached funds flow document as signed to Coutthink, copied to R20, and the signed version of the funds flow document is at 654, and one sees there it's signed by Mrs. Bleasdale, and she's procured the signatures of others on it. Now, what we say about that is that there was, and about this evidence, is that there was material from which the Lieutenant Bailiff could have made the findings that he did in terms of documents and witness evidence, and the findings were open to him, and there was no proper reason for him to interfere with those findings. So far as the request...
Yes, which is the...
so far as the request is concerned, now, I go back to Core 2 at 554. And the undertakings at the foot of the page at clause 5.1a, in which the TDT agrees to procure Oscatello to take and operate the Iceland loan effectively, because it says they procure Oscatello to apply and procure the proceeds of the PPL loans and the shares that they have been given in the furtherance of the business. We know
Which page was that? I'm so sorry.
Sorry, this is 554.
554, thank you.
554. And they know that the business includes Oscatello taking the Iceland loan, because we know that from page 546 that the business includes the advancing and operation of the Iceland loan. So effectively, the TDT is agreeing to procure Oscatello to take and operate the Iceland loan. And in addition, insofar as it should be based on knowledge and acquiescence, obviously the framework agreement is part of a series of agreements, including the overdraft agreement that Oscatello entered into, from which the former trustees know that a purpose of the Iceland loan is to pay off their debt. And we also, your Lordships also saw we have Mrs. Bleasdale's evidence where she was asked by Coupthink to sign a funds flow document, and R20 confirmed that they were happy for her to sign. And R20 were, of course, the investment advisors to the TDT. If your Lordships want to see what their capacity was in more detail, their consultancy agreement, could you bring it up, is on the record at 4590. I think the passage I want is at 4610.
Which part of the record?
Yes. If your Lordships go to the schedule to their consultancy agreement at 4610, I'm sure my junior will provide the reference to the first page of this agreement later if we need it. But it's at item 4, in terms of the services that they provide to the Trust, they include the negotiation and facilitation of arranging finance/refinance as necessary. So I would suggest that particularly with a combination of what what the former trustees agree in the framework agreement, and Lydia Bleasdale signing and procuring signatures with the acquiescence of R20, the investment advisors to the former trustees, that there was sufficient evidence from which the judge below was entitled to find that there was an express or implied request that Oscatello should discharge this debt. And even if that's wrong, I would suggest that beyond any doubt, the former trustees were well aware that Oscatello was paying off this loan because they knew the structure of the agreements, and they knew that there was, as part of those agreements, Oscatello was entering into the overdraft agreement with Coupthink, pursuant to which it was envisaged in an agreement with Coupthink that that debt would be repaid. Now,
but if one were to talk in terms of R20 or the framework as that document does and as R20 does of refinancing would naturally mean the substituting as creditor of Oscatello for Cowting, but you don't put your case that high. That's the original proposition, that it was an express loan.
Well, your Lordship is right to point out the business about the express loan, because the only reason, because it was put before the Lieutenant Bailiff that actually this was a loan agreement, that the former trust, that Oscatello that Oscatello lent the money for this purpose.
Miss Bleasdale.
Yes, which is how Mrs. Bleasdale accounted for it.
But you don't put the case that high?
The loan, my lord. Well, we lost on
put it purely in terms, you lost on it.
We lost on the loan, my lord.
Putting in terms of a restitutionary non-contractual claim.
Well, we are at this stage, my lord, yes. We are at this stage. And I think, in fairness, we are constrained to that at this stage, because the only reason there wasn't a loan, as Lieutenant Bailiff found, was he found the evidence didn't support Mrs. Bleasdale having authority to conclude that loan. If I could show you that to your Lordship, it's... I'm taking it out of order. Yes, it's at page 188 of core bundle 1, back in the judgment of the Lieutenant Bailiff.
Right.
And he deals with the loan, he rejects the loan scenario at 129.
This page?
Page 188, my lord.
Thank you.
And he says this: I see force in the submission that there's nothing in the evidence before the court to support a finding that Mrs. Bleasdale had authority to agree, either on behalf of the former trustees or on behalf of Oscatello, terms of an agreement under which Oscatello lent 39 million odd to the former trustees for the purpose of enabling the former trustees to discharge the debt. There is no evidence to suggest that a loan agreement was approved by the former trustees acting through their directors or by the board of Oscatello. I'm not persuaded the BVI companies have established that sum was paid under the terms of a loan agreement. So he says, basically he says the only reason there's not a loan is because she didn't have authority. And he then goes on to find...
I mean, but by inference, he's saying that nothing else in the framework agreement or anything constitutes a loan.
By inference, yes. And at 130, he does say, but you're liable in restitution, at 130 in the immediately following passage. Now, given that we're now at the unjust enrichment restitutionary stage, there only isn't a loan because of Mrs. Bleasdale's lack of authority. Otherwise, as far as Lieutenant Bailiff was concerned, as far as Mrs. Bleasdale was concerned, there would have been a loan. Now, the question of whether Mrs. Bleasdale...
What would it have been, though? It would have been a sort of retrospective loan, independent of the actual legal nature of the original transaction, because she did book entries sometime in 2008, she said.
No, but she recorded it because she, in accordance with previous practice, she thought that was the appropriate way, she said, to account for it, that effectively Oscatello was owed this money. There was an additional obligation, which is not part of the contract. And I think it's important to bear in mind for the restitutionary argument that the question of whether Mrs. Bleasdale had authority to agree a loan is not the same question as whether her knowledge and expectation should be attributed to either Oscatello or the former trustees for the purposes of a restitutionary claim. It's not the same question, because when we're dealing with a restitutionary claim, one has to deal with the specific question of whose knowledge should be the Oscatello's knowledge and the former trustees' knowledge for this purpose. And a lot of the submissions made against us before the board conflate those two things. They effectively say because she didn't have authority, you can't attribute her knowledge for the purposes of the restitutionary claim. But in our submission, we disagree. We say that Mrs. Bleasdale's knowledge is attributable to both the former trustees and to Oscatello for this purpose, including the specific findings that the Lieutenant Bailiff made about what her expectation was. And we saw what her expectation was back on page 188, which was set out in the passage I read in the last 10 lines of paragraph 128 of the Lieutenant Bailiff's judgment, because she thought it was not going to be gratuitous and would be reimbursed. That's the lines I read out at the end of paragraph 128. And your lordships see at the end of 128 that the Lieutenant Bailiff expressly based himself on her evidence in making findings for the purposes of the restitutionary claim, because he relies on this 2 paragraphs later for finding the former trustees liable on a restitutionary basis. And there was no appeal to the Court of Appeal against the Lieutenant Bailiff's attribution of her knowledge for a restitutionary purpose. So I would query whether that's open to the other parties now to dispute the attribution issue. But it is entirely unsurprising, my lord, in my submission, that the Lieutenant Bailiff made those findings given her position, because she was effectively the acting manager on the Chengi, the TDT side, and she had responsibility to administer the Chengi companies and liaise with R20. There are, I don't want to make too forensic a point, but there are submissions that the former trustees addressed to this court on other appeals which do attribute Mrs. Bleasdale's knowledge to the former trustees and to the BVI companies, most notably the contractual limitation appeal, where in their own submissions they seek to attribute Mrs. Bleasdale's knowledge to both sides of the transaction. Now, in terms of attribution of knowledge, we've included in the bundles the Meridian Global Funds case, which is at Authorities Bundle 10, at tab 122, and the MS number is 23839. And this is a review by Lord Hoffman of the, it's a fairly wide-ranging review, but he was dealing with a specific statute, attribution of acts for a specific statute. But he rather pithily says at letter E on page 507, this is MS 23839, 39. It's just beside, just between E and F. He says, whose act or knowledge or state of mind was for this purpose intended to account as the act, etc., of the company. So one has to look at what purpose, the purpose for which you're attributing an act or attributing knowledge. And in our submission, there can't really be any sensible dispute that the knowledge of an employee can, for some purposes, be attributed to an employer. Particularly if the employee is specifically employed in a particular role, and the knowledge concerns the very activities for which that employee is employed. And Mrs. Bleasdale was specifically employed in this case to administer, on the Oscatello side, to administer the companies, the Chengi companies, and on the former trustees' side, she was the person who did that and who liaised with their investment advisors in relation to the Chengi's transactions. And it is perfectly possible conceptually that an employee involved in negotiating, for example, a contract, won't have the authority to actually sign the contract on behalf of, say, a company. But that doesn't mean their knowledge in relation to that transaction isn't to be attributed to the company. It might very well be. And in this case, it's quite, if Mrs. Bleasdale's knowledge isn't for this purpose, the knowledge of Oscatello and the former trustees, it's very hard to see who else's knowledge would be, or would even be relevant. One of the things that's said against us on this is, well, her evidence is ex post facto, because she's the passage that we've looked at is after the event in early 2008 when she's deciding how to account for the transaction. The answer to that is, my lords, is that she may, in that passage, have been discussing how she proposed to account for the transaction, but it's plainly relevant evidence of what her attitude would have been at the time, since she was the person who actually dealt with the transaction, unless it's going to be sensibly suggested that her understanding changed. But in any event, there was evidence from which the Lieutenant Bailiff could have made made the inferences that he did. And he decided, and determined, having heard the evidence, that as a matter of fact, that the idea that Oscar Teller was providing a gratuitous benefit was inconsistent with Mrs. Bleasdale's evidence. He made that factual finding, and in our submission it was open to him, and it shouldn't have been disturbed. Now,
So the knowledge, but I'm not sure that there's not a slight undistributed middle in this analysis. The knowledge which you ask us to conclude she had, you sometimes put as being that it wasn't intended to be gratuitous.
yes.
And or do you put it as that she knew that Oscar Teller was expecting to be reimbursed? Because those are two different things. It might not be gratuitous because they were under a contractual obligation to do it anyway. Or alternatively, it might not be gratuitous because they were expecting to be reimbursed. And those seem to me to be two very different possibilities. And I'm not quite sure which one you're contending for.
Well, we say both. In fact, that she did not expect it to be gratuitous, and she was expecting Oscar Teller to be reimbursed. I can come to the question in a moment of whether I think I made the point before that Oscar Teller did not enter into an obligation with the former trustees under the framework agreement to make this payment.
But I think you accept that they did enter into an obligation under the framework agreement to oblige themselves to somebody else to use the loan money for that purpose.
It was certainly envisaged that they would, under the framework agreement, they would enter into the overdraft.
An undertaking given on their behalf.
Well, that was a
Oddly enough, by the
TDT undertaking.
trustees.
That was a TDT undertaking. They said they would procure Oscar Teller to do that. It's a fairly fine distinction, I agree, but that's what the contract, that's how it's structured. It's a very detailed contract. It's a fairly fine distinction, and
Be that as it may, Oscar Teller did undertake to Couthing to use the money in that way.
to Couthing, yes, not to the former trustees.
And they entered into that obligation to Couthing because that's what the framework agreement provided for them to do.
Envisaged, and it did envisage that, yes, that they would do that. When I come to the law...
So I'm coming back to my point that the fact
yes.
that Mrs. Bleasdale may have known that this was happening and may not have thought that it was gratuitous could be attributable to the fact that Oscar Teller had a contractual obligation to Couthing to do it.
No, but she also went further and accounted for it as a loan.
Yes, I know she did.
So you obviously
So
thought...
that's why I asked you earlier on whether
Yes.
she was just doing that as a sort of knee-jerk way of dealing with it.
Well, in our submission, not, because that's connected with her not seeing it as gratuitous, that she felt it should be reimbursed. That's the way, she calls it the appropriate way to account for it. In the end, it was up to Lieutenant Bailiff to find these facts, and he heard the evidence, and he made the findings he did in 128 and 130. The inference of allowing the restitutionary claim is that her intention on behalf of both parties was that there would be reimbursement. And the only reason there wasn't a loan to that effect was because you didn't have authority to enter into it. Just before I go to the law, my lords, just a last point on the facts is it suggested, the Court of Appeal suggested that if Mrs. Bleasdale did have such an intention, it may have been unreasonable. In our submission, it seems to be based on them treating the discharge as part of the consideration for the shares. As we've looked at the contract, it wasn't part of the consideration for the shares. In our submission, that's not a fair part of the analysis. Now, turning, if I may, to the law, and let me address first of all let me address in turn the points that are put against us. The first argument put against us is that we are seeking to undermine the contractual regime here by seeking a restitutionary remedy. Now, we entirely accept what is said in Pan Ocean and MacDonald and Costello that you uphold the contractual arrangements. And we entirely accept that. And we entirely accept what Lord Gough said in Pan Ocean, that you get into serious difficulty if you start trying to redistribute risks for which provision is made in an applicable contract. We entirely accept also what he said, that an agreed contractual regime may render inappropriate or unnecessary the provision of a restitutionary remedy. What we say is quite simple, my lords, is that we are not cutting across the contractual regime with any of this. The point is that here is that we are actually outside the contractual regime, because in the contractual scheme, in this case, there was no obligation owed by Oscatella to the former trustees to discharge their debt. The contract, of course, envisages that it would happen, but Oscatella did not owe the former trustees an obligation to that effect. And the contract, therefore, does not provide for the consequences of that happening. And so we're not trying to shift a contractual risk here. We're simply saying the contract doesn't provide for it. If you were to ask oneself under the contractual regime, if Oscatella had failed to pay off the former trustees' debt, could the former trustees have sued Oscatella for a specific performance or for damages for failing to pay that debt off? In our submission, the answer is no, because Oscatella owed no obligation to the former trustees to discharge this debt. So we are, in our submission, outside the contractual scheme, and the only that you can see we're outside the contractual scheme because the only reason the Lieutenant Bailiff found there wasn't a loan agreement, an additional loan agreement, is because Mrs. Bleasdale didn't have authority. And there's...
Would Mr. Chengwiz's guarantee have been released if debt 5962 had not been paid off?
No.
No.
No, he wouldn't. He would have been left with his personal guarantee of that debt. If it had been novation, the personal guarantee would still have applied.
One might say, one, that a fairly large plank in the overall scheme of things wouldn't be in place if after these agreements had been made, Oscatella had then not used Couthing's money to pay off debt 5962.
Well, you could also, you could say that Oscatella would have been a breach of contract to Couthing.
Well, yes, but Couthing wouldn't have been the only or possibly even primary person upset by it.
Well, but it would probably be the person with the first complaint, a legal complaint, because it had an obligation under the purpose of the overdraft. It was said to be to pay off inter alia this debt. But and of course, we can, and this is raised in my friend's arguments, you can have a debate about whether that obligation owed to Couthing to pay the debt off provides a valid basis for the receipt and eliminates the restitutionary remedy. But in my submission, I'm not sure that takes us any further in the analysis, because if our case on the facts is right, then Oscatella both entered into the obligation to Couthing to discharge the debt and paid off the debt at the request of or with the knowledge and consent of the former trustees. When we come to the cases, I can show you, Lordships, Falk and Reed Cleedon and Lee and Dixon, not to be confused with the Arsenal player, I think. Lee against Dixon, I think the case is. You will see in those cases the reference to exposing oneself to a legal liability to pay a debt at someone else's request. So effectively, what the former trustee was saying to Oscatella in the framework agreement clauses I looked at, and in the and through the involvement of R20 in Mrs. Bleasdale's exchanges, was effectively please enter into the overdraft agreement and perform it.
Can I just get straight? The agreement you showed us between Couthing and Oscatella,
yes.
is that an annex to the framework agreement, or is it completely separate?
No, it wasn't annexed.
It's complete.
The same day.
Same day, but it's a completely separate agreement. Is there a reference to it in the framework agreement?
Yeah, yes, there is.
Can we just see that again?
Maybe I think it's schedules. Yes, it's referred to as the Iceland loan and the conditions.
Yes, it's referred to as the what? As the,
It's at page 549.
yeah.
And I should also show you, Lordship, for completeness, at 571.
549, the Iceland loan, yeah, okay. Yeah, that's, you showed us that, and then 571, you say?
Yes, I should show you 571, the middle of the page at 1.4. There are obligations to deliver executed copies of other connected agreements.
574.
571, sorry, I misspoke, 571. And the one, no doubt, that my friends will place heavy reliance on is at 572, where at clause 3.1 at 572, it says at completion, Oscatello shall and TDT shall procure, Oscatello shall deliver executed counterparts of the Iceland loan. The share charge.
Now, that was an obligation owed by Oscatello to who?
It is, my lord, but in my submission, it's not an obligation that says we owe you an obligation to discharge your debt. It's an it's saying we will send you executed counterparties of that loan.
Can I just understand, to whom is the paragraph 3 obligation owed?
No, well, it's owed at completion, so it will be owed to the other parties to the framework.
Including the trustees?
That would be, yes. But
Sorry, this is all on page 5,
page 572, my lord.
on page 572, and yes, I see.
So it's clause 3 and 3.1.
Sorry.
Yes, sorry. I've actually may have conceded too much in the last answer, as my junior has rightly pointed out, because it's an obligation to deliver to Couthink,
Yes,
duly executed counterparts.
yes, but Couthing isn't a party to the framework agreement.
Couthink is a party, yes.
It is a party? Yes.
To the framework agreement, yes, it is, yes.
Oh, sorry. Okay. To whom do you say the obligation is owed? All the other parties to the framework
Well,
agreement, or just to Couthing?
Well, this particular one says to Couthink.
Well, it's delivery to Couthing, but sometimes I can undertake an obligation to you to deliver something to Lord Carnwath.
No, well, I understand that, my lord, but we would say it was a narrower interpretation in this circumstance, that it's an obligation to Couthink, and also, and I do come back to the point that that's not the same as saying I'm undertaking to you to pay your debt.
Yes, the Schedule 2 is governed by clause 4.2 on page 554. At completion, the parties shall do those things required of them in Schedule 2, etc.
Well, your lordship is right to take me there. In fact, I had it marked, so I probably should have gone there before, but the point remains.
Sorry, which paragraph was that?
At 4.2 on 554, my lord. But the point, I think the point remains that I come back to is that there was no obligation assumed in these documents, on a proper reading of the documents, by Oscatello to the former trustees to pay off their debt. I quite accept that that was envisaged in these documents that it would happen. And of course, that also goes in our favour to the knowledge and consent issue, because it means that the former trustees, at a minimum, well, we say they requested it, but at a minimum, they knew and consented to it happening. Now, so far as the law is concerned, my lords, there's been a lot of debate about free acceptance in the written cases. We actually put ourselves primarily on a more conventional analysis of the restitutionary cases. And we say it's been established for quite a long time that where a claimant discharges a defendant's debt at the defendant's express or implied request, or with the defendant's knowledge and consent, then there can be a restitutionary remedy. And that in our submission as a category which is of reasonably long standing. Just a couple of authorities so far as that is concerned, my lords. First of all, Lee against Dixon at bundle 9 at 107. The relevant passage is at 23449, MS 23449. This is a Court of Appeal from 1884.
Could you give me each time the authorities public?
And it's quite a long passage from the Master of the Rolls, which starts, what are the legal conditions, which is about 10 lines into this page. I'm not going to read it all out, but it continues to the top of the following page. But if I may summarize, and I'm sure your lordships may want to look at it in more detail, but effectively he bases himself on there being an express or implied promise or request. Now, of course, implied promise has now been overtaken in the law of restitution as being an inappropriate description, but the gist of it is quite plainly...
the term restitution has been overtaken.
Well, some parts of it...
Seems to
yeah,
be unjust enrichment.
Yes.
Or even Goffin Jones. So.
Indeed, my lord. I was tempted when I came into this case to start calling it unjust enrichment, but there were so many documents that said restitution, I felt that I was probably stuck with it as a starting point. And he also describes at the foot of the page, in the last 5 lines, voluntary payments may be divided into 2 classes. Sometimes money has been expended for the benefit of another person under such circumstances that an option is allowed to him to adopt or decline the benefit. In this case, if he exercises the option to adopt the benefit, he'll be liable to repay the money expended. If he declines, he will not be liable. Sometimes the money is expended for the benefit of another person under such circumstances that he cannot help accepting the benefit. In fact, the fact that he is bound to accept it. In this case, he has no opportunity of exercising any option.
Can I just ask about that in this case? I mean, you've all happily spoken of the FDT debt to Counting being discharged, and we've heard that the personal guarantee for it was discharged. But on what basis? Was that not on the basis of an adoption of the benefit? Because subject to that, I mean, if this really was a payment by Oscatello off its own bat, using monies it had borrowed from Counting purportedly to pay off an obligation of FDT to Counting, then one asks, on what legal basis did it achieve its object? Just because I go along to someone and offer them some money to pay off my neighbour's debt, on the face of it, even if the bank makes book entries, the debt continues to exist, and actually I might in some circumstances be subrogated to the bank against my neighbour, which might be another way in which Oscatello could have put the claim, but it hasn't been put. But, but it's been treated as if somehow this was, it seems to be accepted, somehow it was entirely effective.
I think it's
if it was,
fact that it did discharge the debt.
But how?
Well,
I mean, if it discharged it, it was presumably either discharged it because there was a prior request or because there was a subsequent adoption.
Or I suppose, but there may be both, but we say there was a request.
But I mean, you haven't put it those ways. I mean, you're putting it prior request, but you haven't. Yeah. Nobody has run the case on adoption of the benefit, so we're sort of foreclosed from considering that.
Well, there's something close to it in the knowledge and consent way it's put, because if you know about it and you consent to it being done, it's pretty close to it.
Yes, and you say the inference if they... I mean, presumably, when did the discharge of the personal guarantee take place? At roughly the same time?
Well, it would have been coextensive.
Coextensive. So, but that must have required something bilateral, as between TDT and Counting.
I think the way that is put is that there was no longer any outstanding debt that was guaranteed.
Yes.
It wasn't that the guaranteed document was discharged. It's the fact that there was the debt no longer existed that had been guaranteed.
If you go back to page 654, context in which debt 5962 is being discharged as one of 13 different debts, isn't it? certainly, it's 13 different payments. I'm not sure they necessarily all discharge separate debts, but some of them certainly do. Other loans.
But
You've
if
got
your
a
lordship is,
Linebrook loan, a Thorson loan, an Investec Trust loan, that's this one. Daniela Properties loan, a Violet loan. I mean, that was all right at the heart of the restructuring, wasn't it?
well, these are all part of that restructuring.
All right, they're absolutely central to it, aren't they? That's what the restructuring was doing.
But the restructuring did a number of things, my lord, of course it did.
Why do you pick out this one, is I suppose the question, is it?
Well, because
Why pick out this one debt from this morass of discharges?
Obviously, we're looking
they're
at
not
this
necessarily
one.
all
We're looking at this
discharges. I
one
think there's
debt.
evidence before
We're looking at this one debt because that's the one that's in dispute. But in its context, this was one of a whole raft of different debts that was being discharged as a central part of the structure of the framework agreement.
well, there was the discharge of these other debts. Now, I haven't got into the contractual framework that governs that.
No.
But obviously it was envisaged that other debts would be discharged. But one has to analyse what rights and obligations that gives rise to, because we have here a detailed framework agreement. We have other connected arrangements which have not provided for the legal consequences of the discharge of this debt and did not oblige Oscatella to discharge the debt. And there were detailed arrangements which were entered into by the parties. And I mean, if your lordship there is a more...
Probably better to look at the Iceland, what's called the Iceland loan.
We did look at the Iceland loan, yes. And that was an obligation to Coutthink.
Yes.
Yes. And I take it that it was entered into at the same time. It doesn't provide a legal basis in our submission for the payment which prevents a restitutionary claim, because effectively you are just changing the analysis to say that the request was to agree this with Coutthink and then to pay it off. And it doesn't actually take you a great deal further. It's not a legal basis, and it doesn't mean it therefore comes within the contracts. There is, my lord, at page 650, a slightly illegible, more detailed cash flow that was talked about in the emails, if one wants to actually see where the money's going. There seems to be somebody's taken the trouble to draw lines on that. Now, I'm not going to, it would take too long to decipher them, my lord, but the my lord, on the law, I'd gone to Lee and Dixon. I should show your lordship's Falk, which is in Bundle 6 at 68. And in the MS number, it's Lord Justice Kaufman's at 22130.
But your basic case in answer to my lord is that it's not worth our while trying to work out what's different about all the other payments and why they aren't giving rise to a similar dispute, because they maybe or probably are very different in background.
Well, I don't think anybody's investigated for the purposes of this appeal what rights and obligations arose or were catered for in respect of those. But what I've tried to demonstrate is that there wasn't a relevant contractual obligation in respect of this discharge, and that allows the law of restitution to operate, or unjust enrichment to operate. In Falk, it's Lord Justice Cotton at 241. This is again Court of Appeal, 1886.
What was the page again?
It's at 22130. In the first full paragraph, third line, a man by making a payment in respect of property belonging to another, if he does so without request, is not entitled to any lien or charge on that property for such payment. If he does work upon a house without request, he gets no lien. if money has been paid or the work done at the request of the person entitled to the property, the person paying the money and doing the work has a right of action against the owner for the money paid of the work done at his request. If here there had been circumstances to lead to the conclusion that it was a request by fault that his premium should be paid by Emmanuel, then there would be a claim against fault or his representative for the money, and I do not say there might not be a lien on the policy. And then at 22138, we have Lord Justice Bowen in a similar vein, internal page 249, top of the page, first full paragraph, with regard to ordinary goods upon which labour and money is expended with a view of saving them or benefiting the owner, there can, as it seems to me, according to the common law, be only one principle upon which a claim for repayment can be based, and that is where you can find the facts from which the law will imply a contract to repay or give a lien. It's perfectly true that the inference of an understanding between the parties, which you may translate into other language by calling it an implied contract, is an inference which will unhesitatingly be drawn in cases where the circumstances plainly lead to the conclusion the owner of the saved property knew the other was laying out his money in the expectation of being repaid. In other words, you must have circumstances in which the proper inference is that there is a request to perform the service. It comes to the same thing, etc. Now, you will have seen referred to there that the defendant knew the money was being laid out in the expectation of being repaid. And that is what we say this case is. The last case on this line that I was going to refer your lordships to, I'll spare everyone going to the two Australian cases, but the Re-Cleedon is in bundle 8 at tab 88. It's Court of Appeal in 1938.
MS.
I beg your pardon, 23018.
231.
23018.
888.
This is a decision of the Court of Appeal, 1938, and it was a case where a company director had paid the debts of a subsidiary company, debts which were guaranteed by the company, and the director couldn't claim in the liquidation because the board had not authorised the payments, and there was no recovery in this case because the monies were not paid to the company, they were paid straight to the creditor, so there was no opportunity to reject the benefit effectively. So Wilfred Green, Master of the Rolls at 23031, which is internal page 299, said this, in the middle of the page. This brings me to the substantial question of the case. It was argued that the facts of the present case brought up within a principle for which, for present purposes, I can take as stated with sufficient accuracy in volume 1 of Smith's leading cases. It's there said that if a person knows that the consideration is being rendered for his benefit with an expectation he will pay for it, then if he acquiesces in it being done, taking the benefit of it when done, he will be taken impliedly to have requested it's being done, and that will import a promise to pay for it. In my opinion, the facts of the present case are not sufficient to bring this principle into play. Two things at least are essential for its application, namely knowledge and acquiescence on the part of the person sought to be charged with liability. The knowledge required must, I think, be knowledge which will lead to the possibility of effective action by refusing to accept liability. In the present case, the company had no such knowledge. So two things necessary: knowledge, giving the ability to refuse, and acquiescence. There are some Australian cases we've cited in our submissions. I won't go there, but Lumbers is at bundle 110. I'm sure I'll be provided with the MS number. And O3 Capital Party, that's a High Court of, Lumbers is a High Court of Australia decision. And Lumbers is the New South Wales Court of Appeal at bundle 2 at 24. Now, so my lords, we say first and foremost we are within a more conventional analysis of unjust enrichment, if and to the extent that one has here to address the question of recognition of free acceptance on a more broad basis. If that be necessary, we say that the board should do so. There is, of course, a whole chapter of Gough and Jones now devoted to free acceptance. Your Lordships will find it at MS 26350. It's bundle 17. Bundle 17 at tab 214. MS 26350. And the learned authors at the end of the first paragraph, 1701, say that case law has confirmed the existence of free acceptance as a distinct...
What was the page you're in?
Pages 26350, my lord. I was referring to the last sentence of the first paragraph. Subsequent case law has confirmed the existence of free acceptance as a distinct unjust factor. Obviously, if it doesn't exist, no doubt the authors would be disappointed that one might have to put a line through some of this material. But so far, I'm not going to go through all of the case law. I will just describe it for your Lordships. There's a case called Dry Bulk Handy Holdings, a decision of Mr. Justice Andrew Smith, where at MS 28142, he expresses the view that it is part of English law. There's a rather better known decision called Benedetti and Saurus, where Mr. Justice Patton, at first instance, accepted its existence at MS 27317 to 8. 27317 to 8. In the Court of Appeal, Lady Justice Arden certainly impliedly accepted its existence at paragraphs 116 to 118. She found in that case there had been no request and no implied request, and said there'd be no free acceptance unless there was a free choice to enter into the transaction on the one hand with the benefit of the claimant's services, on the other hand without the benefit of the claimant's services. And in the Supreme Court in that case, it was only referred to in passing descriptively. So far as the criteria for free acceptance are concerned, the criteria are described in the Gough and Jones chapter, which I mentioned a moment ago, which starts at 26350. And one sees at 26354 the foot of the page at 1709, the defendant's knowledge of the impending benefit so as to enable the defendant to have a free choice to refuse the benefit is said to be a requirement. And over the page 26355 at the passage at 1711, 1712, that the defendants knew or ought to have known that the claimant was not acting gratuitously but expected to be paid and by him. And at 1713, page 26356, there must be the opportunity to reject the benefit. So you accept the benefit by choice. There is a debate in the passages here, including in Gough and Jones at 1715 to 16, about whether the cases may be setting the bar too high, but on whether one has a choice. But it's academic for our purposes because we know there was a choice in this case, because the Court of Appeal rather graphically illustrated you could have done this transaction in different ways. In other
Case, I was in the Coys and Kensington. Do you field at all here?
I beg your pardon, my lord?
Does a case called Coys of Kensington?
I'm afraid it's not a case I've reviewed for this purpose, my lord.
Well, your Lordship mentioned it at the previous
Yes.
hearing. It's about the earlier question about whether there's been benefit. It's not about whether free acceptance is an unjust factor.
I mean, they're saying here that they're virtually the same thing, aren't they?
But
Yeah, but
it's a matter of
that's
analysis.
why it's
We've
not
dealt
in
with
this-
it at a different,
Yeah.
different
Not, that's why
stage.
it's not here, yes, I see, thanks.
Just help me on this. It's obviously implicit in all this, whether you look at the old formulation about the grantee not being able to help accepting the benefit, or the very essence of the free acceptance doctrine, that for your claim in restitution or unjust enrichment to work, the trustees must have been free to reject the benefit. But if they had undertaken in the framework agreement to procure that Oscar Tello entered into and operated the Iceland loan agreement in accordance with its terms, and if that agreement provided for the trustees' debt to be discharged by Oscar Tello, how could they freely reject it?
Well, that assumes, well, there's a prior stage, my lord, is it did they have to structure the refinancing in this way at all?
Ah, I'm sorry, I'm only asking you in the context that the framework agreement had been made. So your submission is, well, they didn't have to make the framework agreement.
Well, they didn't have to structure the refinancing in this way.
No, but
As the Court of Appeal said, they said you could have done a deed of innovation, you could have done something else.
But if they did make the framework agreement, why isn't that a contractual structure into which restitution should fear to tread? I mean, if your only answer to the proposition is, well, they didn't have to make the framework agreement, implicit in that is, well, yes, they were no longer freely able to reject the benefit once they had made the framework agreement.
Our submission is they did not have to structure the refinancing in this way. So if you analyse the question as one of choice and ability to reject, they did not have to involve Oscar Tello in discharging their debt in this way. And they could have restructured in a different way, as the Court of Appeal themselves sought to illustrate. And it may come back to the question, my lord, of how one construes the framework agreement, because we read it as not imposing an obligation to do this. It was an obligation to cope things. It wasn't an obligation to the former trustees, and that was our position would have been solved, of course, if Mrs. Bleasdale, with her knowledge and intention, had had the authority as well. We'd have had a loan. We'd have had another loan. But that rather demonstrates that it wasn't intended to be covered by the contract. My lords, just before I finish, and I think I will finish comfortably
Within your allotted time?
within my allotted time, my lord. Free acceptance, if it does exist, that comes in at the unjust factor part of the analysis. And if one goes back to the Banque Financière and Benedetti 4 questions on unjust enrichment, were the former trustees enriched? Well, we've said, well, prima facie, we've cited authority in our written submission to show prima facie the discharge of a debt of another to a third party prima facie constitutes an enrichment. The present trustees dispute the enrichment. They say that there was no enrichment for, I think, 3 reasons. The first 2 of which are that they say that Oscar Tello received valuable corporate assets, the shares, which were more valuable than the debt, which Oscar Tello incurred. And they say in a connected way that although the former trustees' debt was discharged, the value of Oscar Tello as an asset to the former trustees was reduced by an equivalent amount by the fact of payment, the fact that Oscar Tello made the payment. I hope I haven't mischaracterised that, but I think that's what Lord Goldsmith has put. That, in our submission, that comparison itself seeks to undermine the contractual regime, because the consideration paid by Oscar Tello in return for the shares was stipulated expressly in the facility agreement, and it did not include the discharge of the former trustees' debt to Coutthink. So in our submission, that itself undermines the contractual reason to equate the former trustees' benefit in discharging the debt with Oscatella's receipt of the shares. They were not quid pro quos in the contract.
Anyway, it slightly ignores corporate identity.
It does. Well, that's the second point. You can't, it's wrong in principle to use Oscatella's position as a proxy for the former trustees' position as a shareholder, because they are not the same, and there was no attempt to show that there was an equal and equivalent effect on the value of the shares, is what it comes down to. It's wrong, well, in fact, it's wrong in principle because of the separate corporate personality, and it's wrong in practice because there was no attempt to prove that any effect on the shares, the value of the shares at the time.
Can I just ask you about consideration in this context? Is it the law that if in a contract A gets a benefit but enters into two obligations, 1 and 2, to B, the other party to the contract, and only one of those obligations is described as the consideration for the benefit, is it the law that the other one is not part of the consideration for any purpose?
Well, it'll be a matter of construction, my lord. Yes, and
if it's part of the quid pro quo but not described as the consideration?
No, well, there's a very specific clause describing the consideration expressly in this case, saying you get the shares and in return you do this. Now, you issue us shares in Oscatello. Now, absent that, you could see how one could take a more general view of mutual rights and obligations, but this contract has actually said, this is what you're doing for the shares, in return for the shares. And it's, my friends have sought to dismiss that clause as though it was a clause that was necessary just to identify how many shares in Oscatello the parties were getting, but that plainly isn't what the clause says. The clause says is identifying the consideration. That's what it says. Now, if you had a more general contract, it may be susceptible of a more general construction. But we have our consideration clause in this case. Miles, that's the enrichment objection.
What was your third point?
The third enrichment objection, I think, is it said that there was an indemnity, the trustees an indemnity, and they would... I think, yes, it said that it said by the present trustees, I think, that the former trustees could have indemnified themselves and the trust assets anyway in relation to the Coke-Think liability. But that's, in our submission, the trustees' right of indemnity is irrelevant here. It again treats the company's assets as if they were just a trust bank account that the trustees could have dipped into. So that doesn't work to prevent there being enrichment. The second of the questions on unjust enrichment, was it at Oscatella's expense? Yes, well, Oscatella borrowed the money and paid it. So it was at Oscatella's expense. Thirdly, is there an unjust factor? Well, that would be the free acceptance factor if accepted. And then fourthly, is there a change of position defence? The change of position defence is put forward by the former trustees. They say that the former trustees, they say they divested themselves of the shares, the listed shares, and that was a change of position to their detriment, they say. Well, once again, there's a clear statement in the framework agreement that the shares were not in return for the discharge of the debt. So one comes back to that point. And we also make the point that they were obliged by contract to make that transfer anyway, and we refer to the Scottish Equitable case in the Court of Appeal in 2001 so far as that is concerned. My Lords, just before I sit down, I should perhaps just mention this, that the we've had quite a lengthy debate about Article 32 over the last couple of days. There may be, even if Article 32 applies to the loans, there may well be an issue as to whether it indeed applies to restitutionary obligations as well, whether that is a transactional matter. And it doesn't necessarily apply to restitutionary claims. And because, of course, the difference being that a claimant on a restitutionary claim or a tort claim, for example, is an involuntary creditor. And you don't, of course, have the opportunity to take security and so forth if you're in that situation. And so different considerations may apply. So even if it were found that Article 32 were to apply to the loans, it doesn't necessarily follow that it applies to limit the personal liability of the trustees on the restitutionary claim.
Why would a restitutionary obligation arising out of something done at a request of a person not be a transaction or a matter?
Well, they are general words, I accept that, my lord, but of course one has to read them as one reads all words in their context, and with whether, given the different considerations of legislative policy and so on, because I go back to this, the point was often put against me in submissions. A creditor could always take security. Yes. So you can look out for yourself. And that is not the case with involuntary creditors. Now, one then has to ask, what was the legislature in Jersey then trying to do? Was it actually intending that somebody who couldn't protect themselves would also be affected by Article 32(1)(a) as well?
Are we dealing here with an involuntary creditor on your case? Are you not saying that Oscatello agreed to do something at the request of someone else?
Well, not in a situation where it could very easily take security, for example. But
no, I agree with that.
Yes,
but
it's
there may be some
I would suggest that the section
that would fit less easily.
The section either applies to restitutionary claims or it doesn't, I would suggest. So it may be that it would have to work on all analyses and a sensible analysis, and you will get nuances of cases where there may be a request, the restitutionary basis may be something different, it may be a failure of basis, or it may be something else, and the section is going to have to work. And the question then is, does transaction or matter, does transaction or matter affecting the trust include a restitutionary obligation when you've got a creditor that in one way or another may be an involuntary creditor, because you're not, you don't knowingly assume to be the beneficiary of a claim in restitution, because it's an effect that the law implies into facts that have happened. So it's not as though the creditor who ends up being a creditor of a restitutionary claim knowingly enters into that arrangement. It's something that the law implies, yes, in light of the events that have happened.
What do you say a matter means? It's presumably intended to mean something different from or wider than a transaction. Yes. So what does it mean, if not any occasion for a claim?
Well, no, it could mean something like that. I would suggest.
What do you suggest it does mean?
It's a very broad word, my lord. It's hard to draw a line, and to define a line. But I would suggest that it is difficult, having discussed the potential legislative policy of the section, to see why it should have been intended to include within matter a restitutionary claim.
Well, it's not really an answer, is it? I mean, we've got to give some meaning to matter. As you say, it's a very broad word. You say it has a slightly more specific meaning than the breadth of the word might suggest. So what is that meaning?
Well, all I could say to your lordship is that it's likely to be informed by coming straight after a transaction, which I would suggest...
Party to.
Party to.
I mean, it would be... A is understandable if one accepts, as I think is accepted, that it can be varied by agreement. But if one's extending matter outside an area where agreement can operate, I suppose restitution may be on the borders or within that area. But if one was to extend it further to tort, for example, that would be very unfair, potentially. I mean, you would be the victim of tort just because you knew that the person who was about to run into you financially was a trustee.
Well,
it's rather hard to envisage knocking someone down in your capacity as a trustee.
I mean, if you're defrauded by a trustee, yes. If you're defrauded by a trustee, can this really apply? The answer is no. No.
Which indicates that there is a limit to what matter covers. And party two does tend to point more towards a consensual transaction. So we would suggest that it's unlikely that this was thought to be supposed to come a tortious.
It may depend slightly on the nature of the tortious or restitutionary claim. If it's knowing assistance or dishonest receipt or something like that, again, one might be a bit surprised if
Well, there's only a
this
very
applied.
limited range of torts which I would have thought one could commit acting as a trustee, and they would, in the nature of things, be associated with a transaction, just as this restitutionary claim is, even if not a transaction themselves.
But the essence of your restitution claim here is a request
Yeah.
and or free acceptance.
Yeah.
It lies ill, doesn't it, with the concept that it's an involuntary benefit or an involuntary matter, because there will have been a voluntary conferral of a benefit by the creditor, and either a request for it by the trustee or the free acceptance of it by the trustee.
Well,
and in both cases, he'd have to be doing that on behalf of the trust for it to become within Article 32 at all.
I take the point that we are, our restitutionary claim arises out of a situation where, in fact, the request, we say, and the knowledge and consent themselves appear from a contract, which we were party to. But I would also suggest that 32(1)(a), for certainty of application, it's likely to be that it either applies to restitutionary claims or it doesn't, rather than a more nuanced approach. My lords, that was what I was going to say on restitution, unless I can assist you further.
No, thank you very much indeed. So, I think we move on to yeah.
We're ahead in the timetable, so I'm...
We are well ahead of the timetable. You were...
Sorry, could I just organise myself, please, because I wasn't expecting. Coming on now.
half an hour ahead of the timetable.
I thought we were stopping at 4.
10 minutes.
10 minutes? Only 10 minutes, yes, quite right.
Stopping at 4.
Yes, yes, quite right. Yep.
Stop now.
My Lord, I'm happy to go on, but I'm also
Would you
equally prepared to start at 10:30 tomorrow. I think I can deal with the matter in the time that's been given to me
Would
tomorrow.
you save 10 minutes by doing that, probably?
Yeah, let us do it.
You know, I might win a prize too.
Let us adjourn early then. Yeah.
No, it's,
Good. Then 10:30 tomorrow.
Good.